Hey everybody, Todd Vandermine back for another edition of Freedom Steel, former NRA contract lobbyist, Illinois gun law guru. And today's issue, did the Supreme Court just hear another two-way impactful case? Nobody's been talking about this, but in light of today's oral arguments at the Supreme Court, I think they are about to throw a big wet blanket on ATF. And how so? Today's case that was heard at oral arguments was Securities and Exchange Commission v. Jarkesy. So this individual was tried and convicted in an administrative court. And so as I pull it up here, so what happened was this individual, Mr. Jarkesy, was found, there was an enforcement action brought by the SEC for securities fraud, and he had established two hedge funds and brought in over 100 investors, $24 million in assets, and they decided to hold this in front of an administrative law judge. Now, administrative law judges work for the agencies. They are a different type of federal judge appointed to an agency, and they're used in a lot of different agencies. And this has CNN in pants-shitting hysterics by the article that I came across today. I wanted to listen to these arguments just because, but I didn't. Unfortunately, this morning I threw my lower back out. So if I sound a little off a little bit today, I spent the morning at urgent care and I'm in a lot of pain right now, waiting for some drugs to take hold. But I wanted to get this video out because I don't think anybody else has seen or talked about this case. And in light of what some of the justices said today, I think we are on the cusp. I mean, we already know that they're going to tackle the Chevron doctrine, about how much administrative agencies get to do and all that. And you know that we have the bump stock case, the Cargill cases pending in front of the court. They've granted cert. We have the pistol brace rule. We have the frames and receivers rule. And now we have the suit against how they're going to do enforcement actions against dealers, and if you sell one gun, you could be considered a dealer and all that other baloney. Well, here, CNN is noting there were some very interesting comments made by justices on the court. And quoting CNN, key Supreme Court justices expressed deep reservations Wednesday with how the Securities and Exchange Commission brings some enforcement actions for securities fraud, suggesting the court could be poised to pare back on the agency's power in the latest dispute concerning the so-called administrative state to come before the high court. Continuing on here, conservative justices suggested that the agency's decision to allow some disputes to be heard by an in-house administrative law judge instead of filing suit in federal court violates an individual's right to trial by jury under the 7th Amendment. So, hey, what other agency might use administrative law judges? Oh, ATF? Or when ATF does internal administrative sanctions? So this individual was fined $300,000, was told to repay $685,000, and then was barred from various securities industry activities, including serving as an investment advisor. Sounds a lot like what ATF may do if they want to pull somebody's FFL and play those kinds of games. So let's take a look at what the justices had to say. So quoting from the article again, Chief Justice John Roberts worried about an enforcement proceedings with no court and no jury. Roberts said he found it, quote, curious that a person could have a right to a jury until the government decides you don't have that right. Interesting. Neil Gorsuch chimed in here. We'd agree that the right to trial by jury, whether it's criminal or civil, is a very important foundational freedom in American society. Hey, okay. So Samuel Alito asked whether, quote, the right to a trial by jury simply goes out the window when the government brings an enforcement proceeding. Interesting. They talk about how Roberts and Gorsuch was very, they were concerned. They expressed concerns that the SEC plays a more dominant role in enforcement than it has in past decades. Does that sound like ATF to you? Certainly does to me. And then we get down that Justice Brett Kavanaugh pushed back on the government's argument. Quote, it does seem odd from a constitutional perspective to say that a private suit triggers the Article III right to a federal court and a jury against you for money, but a government suit against you for money is somehow exempt from those courts, he said. So here you have it. If we take this, now let's extrapolate this just a little bit. What else is out there where they want to talk about you may not have access to the courts right away? Red flag laws? Illinois' clear and present danger? There was just an article put out, several articles, about a report that state police is touting how well their clear and present danger actions are going. That they took away over 4,000 FOIA cards from people in the last year, and then put another 4,000 people on a list where they would not be able to obtain one because they didn't have a FOIA card at that point in time. All done administratively, all done without a jury, all done without a court, all done in an administrative hearing where you may or may not even get a chance to confront your accuser, which is a whole Sixth Amendment claim that the court just heard in some other stuff. And so I think that this is going to pay dividends and have a very big implication on 2A rights if it goes through. Now, they didn't say what Amy Coney Barrett said in this. They didn't say what Justice Thomas asked about this. Excuse the interruption. I forgot to turn the ringer off on my phone. But the transcripts are not up on the Supreme Court page at the time of this recording. The oral arguments are not up here. So I want to see the questions that Thomas and Barrett posed to the court, because you've already got 4 of the conservatives looking that this whole lack of an opportunity for trial by jury is going to implicate how the SEC and other agencies adjudicate how they're going to adjudicate certain things. This certainly could have a very big implication when it comes to ATF and what they do on revocations and the such. But more than that, if they come down and saying, hey, people fraught with stuff from agencies, not a criminal charge or a civil charge, but people who are being served with some sort of enforcement action by agencies, might ultimately have a right to demand a trial in the court or by a judge or jury, that they don't get simply locked into an administrative proceeding because that's what they said. And I think that if they're talking about, hey, there was no jury here, this individual wanted to be heard by a jury of his peers, or I'm surprised here because of the Sixth Amendment implications about, the right to confront people in an adverse setting, which I think was part of Rahimi, but also part of other things. And I think this is another one of those cases that's a sleeper here. It could be part of the whole disemboweling of the administrative state with taking out Chevron and then handcuffing administrative proceedings and putting some sort of limits on them here. So again, I think this is going to be a net plus for the 2A community when we see this case come around. So let's keep our eyes on this one. And as always, guys, hey, we really appreciate you getting us across the 10,000 subscribers mark. Let's start setting our sights on that 25,000. Keep growing from there. Please don't forget to like, subscribe, copy and paste the link for this video around, share it to social media, because you're going to hear commentary here like you don't hear in a lot of other places. And we really try not to do the clickbait titles on here, although this one would have been, was there a case today at the Supreme Court that is going to impact the 2A? I believe there was, but hey, is this SC? We'll have a more fair headline on there, so we don't just try to bait people in for stuff. But as always, guys, thank you once again, and frag out.